Today's video is really going to showcase just how low and pathetic you can be when you think you're anonymous on the internet, and just what happens when creators weaponize their audiences for retaliatory purposes. We are going to be listening to the bail hearing of Lane Meyers. Now, if you don't know who Lane Meyers is, he is essentially a nobody who happens to be a deranged lunatic who is being charged with multiple counts of felony harassment for targeting a woman who works at the University of Arizona whose only crime is she happens to be married to a prosecutor. I really hope you enjoy this. It is a little bit on the longer side, but I found the entire hearing absolutely fascinating.
We're ready, Your Honor.
All right, Mr. Parvin, are you ready?
Sure.
State of Arizona versus Lane Jeffrey Meyers, IC 003692. Parties, please announce.
Rachel Stiles for the state. Your Honor, we do have the victim present.
All right.
This is William Parvin, Mr. Myers. He is present in custody.
Good afternoon, Mr. Myers.
Good afternoon, ma'am.
This is the time set for the no bond hearing. Before we proceed, I do need to let everyone know the court did receive a request under Rule 122 to stream proceedings. I do want to let everyone know that they are streaming on YouTube this afternoon using the court's YouTube channel. So we are streaming in response to that request. State ready to proceed on the no bond hearing?
Yes, Your Honor. Your Honor, the state calls Detective Eric Brown.
Detective Brown, come on up. I'm going to have you be sworn in before you have a seat here next to me. Microphone towards you. All right, Ms. Stiles, whenever you're ready.
Could you please introduce yourself?
Yes, my name is Eric Brown, and I'm a detective with the Tucson Police Department, and I've been employed with the City of Tucson for 21 years, and in that 21 years, I've been a detective for the past 15 years.
Do you know an individual by the name of Lane Meyers?
I do.
And
Good.
do you see that person in the courtroom today?
Yes, he's seated to my left here at the defense table.
Your Honor, if the record could reflect that he's identified the defendant.
I'd like a little bit more on that. Seated at the defense tables.
Okay, would you
He's
describe what he's wearing?
at the defense table to my left on the in the orange jumpsuit with the beard and full hair.
The record will reflect identification of Mr. Meyers.
And do you know a person by the name of Shannon Walker?
I do. She's a victim of one of the cases that I've been working.
And how are Lane Meyers and Shannon Walker connected?
So they became connected through Shannon's husband, who is a prosecutor over at Tucson City Court. The relationship started, or at least my case started, due to Mr. Meyers contacting Miss Walker through the court case through Tucson City Court. That started with phone calls to her office at the U of A, and then him going down to the University of Arizona to try to speak with her in person, which then led to him creating YouTube videos speaking about Miss Walker and her husband and the conduct that he didn't agree with.
I'm going to object on hearsay. I realize the purpose of this hearing, but since everybody's watching on YouTube, I'm just objecting anyways, and the court can explain why that'd be illegal.
So I will overrule. Hearsay is admissible at these proceedings. Ms. Stiles, I am going to ask you to lay some foundation as to witnesses who are going to be available at further proceedings in this trial before you go forward with that, however.
Yes. So, Detective, for this information that you gathered, how did you gather this information?
There were reports from the victim to the Tucson Police Department asking us to investigate harassment charges and later on violations of an injunction against harassment that she had filed against Mr. Meyers.
And have you spoken with the victim?
I have.
And are you aware of whether she will be available to testify at trial?
She will be.
Now, the information that you were gathering, was that just from Ms. Walker, or were you gathering it from other sources?
So I was gathering it from Miss Walker, but I was also gathering it from Mr. Meyers' YouTube channel that he is active on. I wouldn't say on a daily basis, but he's very active on it. So obtaining videos through his YouTube page and through other YouTube pages that associate with his page.
Were you also in contact with Matthew Walker?
I was, yes.
Okay. Was he providing information to you about what was going on?
He did also provide information in relation to Shannon being contacted due to his work with a case that would involve Mr. Meyers over at Tucson City Court.
And in speaking with him, are you aware of whether he will be available to testify at trial?
He will be available as well.
So now you referenced that Mr. Meyers has a YouTube channel. How do you know that that's Mr. Meyers' YouTube channel?
Because you can clearly see him on the YouTube channel. He appears physically. He often says his name, so it's clearly him.
So in relation to what Mr. Meyers was doing with Ms. Walker, when did that approximately start?
It approximately started September, October of 2024.
And then how often has this been going on?
So it's still currently going to this date. The harassment that she felt was up to the point where she obtained the injunction against harassment in October of 2024. That injunction was then modified in November of 2024, and it is still active today. And she still is receiving things that are harassing in nature to this date.
Okay. So prior to getting those injunctions, can you just give a brief description of what type of behavior was happening that led to the injunction?
So she was receiving phone calls from third parties. Mr. Meyer went on his page and he was encouraging his followers to reach out and contact Ms. Walker in relation to the conduct of her husband, to just let her know that he was corrupt and that they just were generally not good people, which led to her email and phone number being flooded with harassing emails and phone calls.
And in your investigation, were you able to make any determination about whether there was any connection with Shannon Walker to Lane Meyers outside of the fact that her husband was employed as a prosecutor at the Tucson City Court?
No, there was not. To my knowledge, they had never spoken any time prior to the court cases.
Okay. And so you referenced that she got an injunction. And Your Honor, may I approach? Yes. Your Honor, I'm going to approach with states 3, 4, and 5.
Of course.
Looking at 3, 4, and 5, do you recognize those documents?
I do.
And how do you recognize them?
So the first one, Exhibit 3, would be an injunction against harassment that was filed with Superior Court on October 10th of 2024. This is the original petition that Ms. Walker filed for. And then Exhibit 4 is the amended, updated injunction against harassment that was filed on November 14th of 2024 at a contestation hearing where Mr. Meyers received a copy of the updated injunction at that time. Exhibit 5 shows here is just minute entries from that hearing, which just verifies that the defendant received a copy of the amended injunction.
And from your knowledge of the case, do those involve the same Lane Meyers that's present here in the courtroom today?
Yes, they did.
And Your Honor, these documents are also stamped and signed, so they're also self-authenticating. So I'd move to admit states 3, 4, and 5.
Any objection, Mr. Parvin?
No objection.
We'll show 3, 4, and 5 are admitted. Thank you.
And then you said that in November the injunction was amended. Was that injunction was that served on Mr. Meyers?
It was. He received a copy of it on that day on November 14th.
And is that November injunction still active?
It is, yes.
What type of conduct was prohibited in the injunction?
The injunction prohibited Mr. Meyers from contacting the victim at all, and then it also prohibited him from posting or displaying the victim's contact information, which would include her work information on any social media platform. He was also prohibited from having any direct or indirect contact with Ms. Walker.
Have there been issues with Mr. Meyers posting videos and people reaching out to the victim?
Yes. So he's continued to post her work information to include her phone number and email, to which then she's been getting harassing phone calls and emails pretty much on a daily basis from that time.
Has there been evidence that you've seen that indicated that Mr. Meyers knew that his followers on YouTube were contacting the victim?
He has spoken about it on his YouTube channel, yes.
Now, are you aware of charges currently pending for Mr. Meyers?
Yes, there are current charges pending.
And how are you aware of those?
I was a detective that investigated that case.
Your Honor, may I approach the state 6 through 10?
Yes.
Could you please take a look at those?
Yes, number 6 is an indictment with Lane Jeffrey Meyers listed as the defendant with the counts that he was charged with in that court case. I can read them if you prefer.
Yeah, that's okay. Can you go, and then what's the next document?
So Exhibit 7 looks like the arraignment order and appointment of attorney for Lane Meyers. And number 8 is the court paperwork for the initial appearance and arraignment, and the minute entries from that court date.
And then for the arraignment date, what date was that?
It looks like it was on April 15th of 2025 at 9 a.m.
That hasn't even happened.
Or, no, that's the first date listed here. Let's see. The judge signed it on March 14th, 2025.
So March 14th, 2025?
Yes.
And then what's the next document?
So Court 8 was the minute entries from that initial appearance and arraignment.
And again, what is the date on that one?
Also March 14th of 2025. And then Exhibit 9 will be the appearance order with the release conditions issued by the court. And that also is dated on March 14th of 2025. And Exhibit 10 will be the minute entries from the status conference and the media request from dated March 19th of 2025.
Okay, and who is the individual that's for all of those?
And that would be Lane
Documents.
Jeffrey Meyers is listed as the defendant on all of these exhibits.
Is that, and from your knowledge of the case, is that the Lane Meyers that's here in the courtroom today?
It is, yes.
Your Honor, I'd move to admit states 6 through 10. They all have the seal and they all have the signature indicating they're self-authenticating, and he's established the foundation that involves this defendant.
Mr. Parvin, any objection?
No objection.
We'll show that states 6 through 10 are admitted.
So following that initial appearance that happened back on March 14th of 2025, did Mr. Meyers post any additional content regarding the victim, Ms. Walker?
He has, yes. To include on March 16th, he posted a video to his YouTube channel called Slapping Style Sanctions. During that video, he did display the active injunction against harassment and did display the victim's work information to include her work address.
Not a crime.
And then on March 17th, he posted another video entitled Publicly Available Public Information, I believe. And during that video, he goes to the University of Arizona's website. He scrolls over her biography page and shows her work phone number and work email addresses again.
And have you had a chance to review those videos?
I have, yes.
And prior to coming here to court today, did you review clips of those videos?
I did, yes.
Your Honor, I'd move to admit states 11 and states 13, which are the clips, and then states 12 and 14. I'm not intending to play, but they're the full videos so that we have them for the record.
This I would object to, Your Honor, because I'm not sure what we're viewing or if you've rehearsed this hearing at this point.
You want to lay just a little bit more foundation as far as what's on 11 and 13?
All right, so talking about the slapping style sanction video, can you describe more of that video?
So in that video, he's discussing the court cases. He's discussing the police reports. There's mention of in one of the police reports where it mentioned that Lane and the victim were exes. And then he also just discusses the injunction and again posts her information, her contact information that was prohibited by the injunction.
And as far as how do you know that Mr. Meyers was posting this?
He was in the video.
And where was this video?
It was posted on his YouTube channel. I believe it was on one of his live streams.
And then you referenced that a police report said something about Shannon being an ex. Can you explain that?
Yes, so there was an initial report that was taken by an officer where the officer mentioned that Mr. Meyers was Miss Walker's ex, which is not true. But I'm just not sure how that part got into the report. It just was a typo by the officer.
And so was that was discussed in that video?
Yes.
And the clip that for that video, the slapping style sanction clip that for that video, the slapping style sanction clip that you watched prior to this hearing for the slapping style sanctions, what is that clip showing?
It shows just a portion of that video where it shows the injunction being displayed and the victim's work information being displayed on that video.
And I think, Ms. Stiles, you'd indicated that states 12 you don't intend to play, but it's actually the entirety as opposed to a clip. Is that right?
That's correct, Your Honor.
All right, Mr. Parvin.
Yeah, so the state's intending to play a clip because I have some concerns here about whether any information was shown, at least on one of these videos.
And Your Honor, just for the purposes of this, I'm going to ask just to be able to play it for the court without putting it up on the screen because we are showing information for the victim.
I just want to make argument. At least I'm familiar with what I think is going to be shown, but at least on one of these, I'd like to object. I don't believe any content was shown. So as long as I can see it too, I'm fine with that. So I can make arguments.
All right, so I am going to show over defense's objection that states 11 is admitted for the court and the parties to review. I will admit states 12 for purposes of the record. Did you want to go on with 13 and 14 or show 11 first?
I'd like to do 13 and 14 and lay more foundation so then we can view them all at the same time. So as far as the 13, this publicly available public information, what does that video show?
So it's just a video where you can view the computer screen on Mr. Meyers' YouTube channel, and he's going to the University of Arizona's website. He clicks on the College of Law page. He goes to Miss Walker's information where it displays her University of Arizona picture. It then displays her work phone number, her work email address, and kind of just scrolls down the information. And he leaves that page, goes to a different section of the U of A website, scrolls down a little bit further, finds a little bit more information about the victim and her job at the U of A. So it does clearly display her email address and work phone number.
Okay. And during that video, is there any audio?
There doesn't appear to be any audio. There is never anything spoken during the duration of that video.
So how do you know that it was Mr. Meyers that posted that video?
He admitted to making that video on one of his jail calls.
Your Honor, again, I move to admit states 13, which is the clip, and states 14, which is the full video.
Mr. Parvin, anything else to add to your record?
I'm going to object, but again, I understand the court's ruling on that. I mean, I'll object, and I haven't seen, well, I have an idea of what's in it. I'm just not sure.
All right, so we'll show over defense's objection. I'll admit 13 that the parties in the court will review and 14 just for purposes of the record. And Mr. Parvin, obviously, if there's anything more on the video that you want to show, those have been admitted, you can certainly do that.
Your Honor, I think this would be a good time for the court to review before we move on to the next portion.
All right, Mr. Parvin is going to have an opportunity to come up as well. So if Mr. Parvin, you want to come up, we'll play this up here by the witness stand.
Sure. This is which one we playing first, or?
States 11.
Is there any way for me to mute this, or do you need me to mute this at all? I don't think so, but.
No. I don't think it's the audio. Yes, absolutely. Come on up.
I turned off the outfit.
All right. I just want Mr. Parvin to be able to. are we moving on to states 12? All right, states 12 will be next. All right, before we leave these, the court has two questions. I think the state had indicated March 16th and March 17th. Where on the videos do you see that they were posted on that date? Or is that something you're going to get to discuss? I can ask you. I mean, he can answer my question as well. So the court's question is for the first video slapping style sanction. How is it that you're able to tell from that video that it was posted on 16th?
So we go to the direct YouTube page itself.
I need you to make sure you're on the record for this.
Sorry.
So make sure that everyone can
Sorry.
hear.
So the date and timestamp, if you go to his direct YouTube page, it will have a date and timestamp right below the title of the video.
And that was something that you personally observed?
Yes.
And what about the one for publicly available public information? How were you able to determine that that was on the 17th of March?
The same manner.
Okay. All right. Thank you.
Sorry.
So, how many followers does Mr. Meyers have on his YouTube channel?
Approximately 15 to 16,000, I believe.
And as far as with his YouTube channel, does he have other YouTube channels that seem to associate with his channel?
Yes, he does have some other friends that he will frequently appear on their YouTube channels and discuss the case as well.
And after these videos are posted showing Ms. Walker's work address and her work phone number, does she get communications from followers of Lane Meyers?
She has. Since March 17th, she's gotten approximately 58 harassing emails and 17 harassing voice messages.
Objection. Now we're going past the date of alleged incidents that potential indictments are coming from. I asked for relevance purposes, we stick to the March 17th or before.
I'm going to overrule it. I think the court can consider it for purposes of this hearing. Ms. Stiles?
And have you been gathering emails that were sent to Ms. Walker?
I have been, yes.
And how were you getting those?
Those emails are being forwarded or sent to me by Ms. Walker.
And I'm going to show you what's been marked as States 15. And I'd also like to approach with States 16 and 17.
You may.
And what is States 15?
15 looks like a stack of emails that have been sent to the Mrs. Walker.
Okay, and what is the time frame for those emails?
This one on the top here is March 15th of 2025. We have March 16th, 17th, 18th, the 18th again, 18th, March 19th, as well as a voice message from March 19th and another email from March 19th.
And were those emails sent to Ms. Walker through her email address that had been posted in those two videos?
Yes, to her email address at the University of Arizona.
Do those represent all of the emails that she has been receiving?
No, this is just a small portion of the emails that she has received over the course of all the events.
Okay. All right. Your Honor, I'd move to admit States 15.
Any objection?
Yes, I don't know for sure where these emails came from, and they're not from Mr. Meyers, so I have an objection on that basis.
You want to lay a little more foundation about where they came from?
What is your understanding of where these emails are coming from?
These are emails that were coming from followers through YouTube on either Mr. Meyers' channel or associated YouTube channel that majority of these emails are speaking about Mr. Meyers' case or about her corruption or her husband's corruption.
And these emails in this exhibit came to you from Ms. Walker, is that correct?
Yes, all of these were forwarded to me from Mrs. Walker.
Okay, thank you.
I'd
Anything
move
else?
again.
Anything else, Mr. Parvin?
Just that again, I'm concerned with the dates, past the 17th and also some before. So I'm relevant concerns on all these emails. There's been no proof from Mr. Meyers or who's doing them directly. There's no connection made at this point. I would argue that still I have some concerns with the relevance.
I do find that they are relevant for purposes of this proceeding, especially given the date ranges March 15th to March 19th. I'm going to overrule the objection. States 15 is admitted.
And what were the nature of these emails?
There's a wide variety. These emails go from calling her names, telling her she should be fired from her job, that her husband should be fired from his job, all the way up to wishing death upon her, wishing that she gets cancer, wishing that she outlives her kids so she can see her children die before she dies. It's just a wide range of general threats and harassment in general.
And is there one that's particularly serious as far as the threats to her contained within there? Do you want to look through?
Yes, there's one here that was sent on March 19th. It's entitled "You Whore Deserve to Be Exterminated." This one just discusses the fact that he feels that she should be gunned down without mercy, that they hope she experiences a painful death, calls her a degenerate cunt, hopes she outlives her to see her children die before she meets her end. Just basically encouraging her to kill herself and do the world a favor.
And then states 16 and 17, what are those?
So 16 is looks like a 28-second voicemail with the date of 3/16 of 2025 on it.
And then what is states 17?
17 is a 41-second voicemail marked March 19th of 2025.
And those voicemails, how do you know when those were collected?
So these voice messages were collected by Mrs. Walker and then also forwarded to me through my work email, much like the actual paper emails were.
And are these voice messages that she received on her work phone?
Yes, these are voice messages that she received through her work phone at the University of Arizona.
Is that with this number that was posted by Mr. Meyers?
Yes, the number that was displayed in the YouTube videos.
And did you have a chance to listen to both of those prior to coming here to testify today?
Yes.
Your Honor, I'd move to admit states 16 and state 17.
Mr. Parvin?
An objection. I don't know for sure which one this is. And again, it's on March 19th, which is, I'm not sure the relevance of it compared to what we're dealing with happened March 17th or sooner.
Over the defense objection, I will admit states 16 and 17. And Detective, we're not saying that any of these are actually Mr. Meyers. These are other people that are sending these emails and voicemails. Is
Correct.
that right?
These are all other people. These are all third parties.
Okay.
And did you want 15 as well, ma'am?
Yes, 15, 16, and 17 have all been admitted.
And Your Honor, permission to publish those voicemails?
Yes, Ms. Stiles, go ahead. And are you going to play those?
Yes. So we've got state 16 first. Just want to make sure.
And keep harassing innocent citizens, then we're going to make sure we redress you at your house, in front of your neighbors, in front of your family, and let them know what a Nazi piece of shit you are.
I don't think that played the whole thing. Your Honor, if I could play, I think it cut off part of it. Is that okay?
Yes.
Seemed like it.
We're going to make sure we redress our grievances with you, and if that's going to be in front of your neighbors, in front of your family, then so be it. You want to keep it up, then keep harassing innocent citizens, then we're going to make sure we redress you at your house, in front of your neighbors, in front of your family, and let them know what a Nazi piece of shit you are.
And then state 17.
Oh, maybe I should.
Because she's a state actor.
Okay, you know what?
At the University of Arizona College of Law, but yet you filed false charges. I'm curious too how long you dated Lane when he was your boyfriend. Were you betraying Matt when you were doing that? Or was this before you and Matt got married? Excuse me. You're disgusting, lady. I can't wait for the world to get sick of your crap. All right, bye.
And that last one we listened to, state 17, was that referencing one of the videos he had posted?
Yeah, so the information from that voice message would have came from the slapping style sanctions video where he's discussing the police reports where it first mentions that Mrs. Walker and Lane were exes or in a relationship.
Other than these two, have there been additional voicemails sent since that March 14, 2025 date to Miss Walker on her work phone number?
Yes.
And what is the nature of the type of voicemail she's been getting?
Very similar to those voice messages right there, just basically telling her she's a horrible human being, how she should be fired from her job, how she should kill herself, making statements about going to her house or confronting her family in front of her neighbors. It's more of the same thing, but just kind of explained in different methods.
And in your review of both the emails and the voicemails, has there been any additional threatening tones other than what you described in here?
No, they're all pretty similar to that nature and that tone. Just mentioning how she should die and how she should kill herself and how nobody would regret the fact that if she was dead.
And in your conversations with Ms. Walker, has she seemed concerned about these voicemails and the emails that she's been receiving?
Yes, she's been concerned for her safety as well as the safety of her family due to the fact that people are calling and emailing her and letting her know that they're going to try to track her down. There's posts about people requesting someone to post her actual address so they can go to her home address. So she does have some safety concerns as far as her and her family.
And in her expression of the safety concerns, is this just in passing of like their annoyance, or is she concerned? Is it like an ongoing safety concern?
An ongoing safety concern. Like I said, she gets voice messages and emails nearly on a daily basis. So to her, the threat is very real.
Is she concerned about just Mr. Meyers, or is she concerned about the people leaving messages and sending voicemails?
I believe she's concerned with both.
In just one moment. And then just Detective, in your investigation, did you find any reason that these people would have been contacting Miss Walker outside of the connection to Mr. Meyers?
No, I do not believe that any of these folks would be in contact with her or at least even know who she was if it wasn't for Mr. Meyers' YouTube channel.
I have no further questions.
Mr. Parvin, cross-examination.
On the first video, you mentioned Mr. Meyers allegedly posted the injunction.
Oh, which on the
That a video in the state's exhibit was 11 or?
the slapping style sanctions video?
Yes.
Yes.
He didn't post any victims' work information on their websites or otherwise. He just talked about a current case he's involved with.
He spoke about the current case, but then he also posted the injunction that physically displayed her work address, and then he actually highlighted it in the video.
He was showing the actual document where it says the residence was confidential.
It showed her personal residence was confidential, and then it showed her employment address, which is what,
It was his court document for that purpose.
yes, it was his copy of
His case.
yes, it was his copy of the injunction.
He was talking about his beliefs in the case and how he would defend against it.
Yes.
Yeah. There, you mentioned there's no audio on the next video. This is public information.
Correct. There's no audio on that video.
Showing lots of different people and addresses to the University of Arizona.
He did. He scrolled through the victim's information, displayed the victim's information, and then also went to the employment directory. And obviously, he displayed a lot of other folks that work at the University of Arizona's information to then include the victims again as well.
So lots of people were displayed.
Yes.
And he labeled this as public information.
Yes.
Now, on that first one, the injunction, that doesn't list the email of Ms. Walker, does it?
Displayed?
Well, you said you displayed the court document, the injunction. That doesn't list her email on there.
No, that document does not list her email, no.
It's just the University of Arizona, that's all it said?
Just the College of Law, the address for the University of Arizona College of Law.
Yeah. This happened over the week, like between March 15th, 16th, around that time?
That video was posted on March 16th.
But after the last one was the 17th, is that right?
And then the public information video was posted on the 17th, yes.
Nothing on the 18th.
I'm not sure if he posted on the 18th, but I didn't think that there was anything relevant to this on the 18th, no.
The state actor part. We have to discuss that in this court. It'd be malpractice if you don't.
Do you consider Ms. Walker a state actor?
What do you mean?
Yes, a public employee subject to public information.
Well, she is an employee of the University of Arizona, but I'm not party to what her particular role there is and whether or not she is a specific a state actor, as you put it.
As far as you know, she's a professor, or she works there, or?
Yes, she's employed there, yes.
I want to say that she's a state actor under 1983. She's a state actor under Section 1983, USC 42, U.S. Code. She's acts under the color of state and pursuant to ARS 12751.
Mr. Meyers, your attorney is representing you here today, so I need you.
Can I approach quickly on the topic?
Yes, Mr. Meyers, I need you to stay quiet.
Ma'am.
Thank you. On or off the record?
Be off the record, please.
All right, let's go back on the record. All right, so Mr. Meyers, I know there are things that you want to be able to say, and Mr. Parvin knows the purpose of this hearing today. And this is solely about whether or not the court is going to hold you without bond, and there's a specific rule that the court has to follow to do that. So there may be other arguments if the state does indict you on new charges. That hasn't even happened yet, and you're going to have the opportunity to do that at a later time.
Thank you.
Do you understand all of that? Okay. All right. Mr. Parvin, do you want to proceed?
So you presented earlier a document about what happened on March 14th for an arraignment.
Yes.
Still have that in front of you?
I do not know.
I have a copy as well. I just don't know which citizen.
The court has it.
Which exhibit was it, Mr. Parvin?
I'm not sure.
It
I
should
have
be.
a copy of it. Which was it for you?
Which one are you
The
looking at?
arraignment.
I believe it was the arraignment.
I think that
document.
maybe eight or nine.
Let me grab those. I'm going to hand 7 through 10 back to the witness. So if you have any questions on those.
So you're talking about the one that says arraignment order and order RE appointment of attorney? That one? Okay. Yes, I have that one.
Can you see what day it was filed?
March 14th.
What about, can you see at the top? That just happened March 14th. Do you see at the top where it says the stamped filing date?
Yes.
What date was that?
March 14th.
Does yours not have a copy that says file Gary L. Harrison, Clerk Superior Court on March 17th? Do you see where it says this?
No, so the stamp right here, and then it has 25 March 14, and then the timestamp, and then D. Wandale Deputy.
Okay, then I do have a different exhibit because I didn't mind. So, mark that here. I want to argue that it was actually March 17th. I'm not sure why yours doesn't have the filing date.
It has a different, I mean, you can go see.
Do you want to take a look at this one, Mr. Parvin, to see?
Yes, it looks like we have different copies of this.
Yeah, because this one does look like it was filed by the clerk's office on March 14th of 2025. So and this one's certified by the clerk. So if you want to take a look at that one.
This is April. Okay, Matt Gross, the one I copied, I think he has this one as well.
Yeah, did you get that one marked?
This one, I think he's just looking at the wrong one. I see right in front of him, which exhibits.
Yeah, of course.
Which exhibit was this one?
This one right here is Exhibit 8.
Okay. So if he states Exhibit 8, the one I'd be looking at then.
All right.
And yeah, and this one looks like the minute entries from the initial appearance and arraignment.
Okay. So looking at State Exhibit 8, do you see where the minute entries were entered on March 17th?
Are you speaking about the date up here in the right-hand corner?
Yes.
Yes, so filed Gary Harrison, yes, filed 3/17/2025.
Entries?
Yes, the date on that is March 14th, yes.
Yeah, but they were filed with minute entry on March 17th.
Yes, this was filed on March 17th.
And as you previously testified, to your knowledge, the conduct stopped on the 18th. So there's nothing after the 17th. That was the last time.
No, the conduct hasn't stopped.
The last video you hear, as far as so the video on the 16th, I think you said maybe 17th, but nothing on the 18th.
No, so the videos that were presented were from March 16th and March 17th.
Do you have a timestamp for the 17th, or just know it's on the mark? Do you have a timestamp for a specific time on the 17th, or you just know it was on the 17th?
I don't have that information with me today, no.
I have nothing further.
Any redirect?
No, Your Honor.
Would you like me to take that?
All right. Can this witness be excused?
Yes, Your Honor.
All right, go ahead and step down.
Thank you, ma'am.
Any other witnesses by the state?
No, Your Honor.
Are we ready for argument?
Yes.
I don't think sure. I mean, I should say today, but I think Mr. Meyers has a right if he wants to speak today, but I'm just asking if he wants to.
So, Mr. Parvin, you're the attorney of record today. I know, again, we got started late. It's 10 minutes to 5. We are going to stop a little before 5 so that court staff and corrections can do what they need to do. So if the parties prefer, I know it's an inconvenience, we can come back tomorrow afternoon for purposes of argument if you would prefer to do that, and that will give you time to talk to Mr. Myers.
Because I believe I don't know if he wants to testify. I think we still have a right to present witnesses as well today.
You do.
So I'm asking you, do you want to talk about this, come back tomorrow? Or
Of course.
I think that'd be best. Let me make sure that because I thought I actually, depending on the time tomorrow, let me look. Would be tomorrow at what time?
I think we could come back tomorrow afternoon at 1:30 or 2. Let me just check.
2. Today a bench trial did go. It was a quick, so I got it done within an hour. It's probably this one I imagine would also be about the same, starting at 1 or 1:30. So I'd rather do a similar time at 2:30 or 3. I don't anticipate it's taking much longer.
All right. So I can come back anytime tomorrow afternoon. So if you wanted to even start at 2:30, I don't know how much longer we think it's going to take.
It would depend. I talk to Mr. Meyers for whether you want to testify or just make arguments, or I would make arguments.
All right, well, I'll let you two discuss that. Let's come back at 2 o'clock tomorrow afternoon. Ms. Stiles, does that work for you and also the victims?
Can we do 2:30 to case that trial? Again, I don't know if it's,
Yeah.
I'm worried about. Let's do 2:30 to make sure.
2:30 is fine. So we'll show continuing the no bond hearing tomorrow afternoon at 2:30 in this division. All right, is there anything else then we need to do today? We'll proceed with the defense tomorrow and take arguments.
I have nothing further today, Your Honor.
All right, anything else, Mr. Parvin?
No, Your Honor, thank you.
All right, Mr. Meyers, we're going to see you back tomorrow afternoon at 2:30. You can talk with your attorney about whether or not you want to testify.
Is there a way to talk to him?
All right, let's go back on the record in State of Arizona versus Lane Jeffrey Meyers, IC 003692. Parties, please announce.
Rachel Stiles for the state, and Your Honor, the victim is present.
Good afternoon, Ms. Stiles.
William Parvin, Mr. Meyers, and he is present in custody.
Lane Meyers.
Good afternoon, Mr. Meyers. Go ahead and be seated, everyone. All right, so a couple of quick housekeeping matters. I do want everyone to know, just like yesterday, the matter is being streamed on the court's YouTube channel. So that is what's being done today as it was yesterday, so the public can have access to the hearing. Yesterday we did have a request under Rule 122H to record proceedings. What I want to make very clear is that under that rule it allows audio recording only, does not allow video recording. So the court wants to make it very clear here today that there will be no video recording of the proceedings in this matter. That said, I think we're ready to proceed. Mr. Parvin.
Yes, Your Honor. Defense would like to proceed to argument.
Okay, so Mr. Meyers is not going to be testifying today?
No, we spoke about it, and he's shaking his head no, he's not going to testify.
Okay, and it's my understanding, Mr. Parvin, that you did have an opportunity to meet with Mr. Myers today in the courthouse prior to the proceeding. Is that correct?
Yes, and we discussed how this is going to proceed today.
Great, okay. I guess we're ready for argument. Ms. Stiles.
Your Honor, on March 14th, 2025, Mr. Myers was present for his arraignment, which was also his initial appearance, where he did receive release conditions in this case for felony offenses for which he has been charged. After that date, then he went and posted these two videos. These two videos from March 16th and March 17th were both done while he was on release. At the time, he did have the active injunction against harassment, which is an element of the aggravated harassment statute. As the evidence has shown, that injunction was served. It was in favor of the victim. It was served on Mr. Myers while he was in court, and it was still valid as of the date of these offenses. For aggravated harassment, we have to show that the defendant with intent to harass or knowing that he was harassing another person, and then it's that he communicated or caused a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means in a manner that harassed. And so for that, he caused a communication because he went onto his YouTube channel knowing he has, over 15,000 followers. He went onto that channel and he posted the contact information for the work contact information for our victim, Shannon Walker. And the only reason that he would do that is because he's trying to elicit people to make the contact with her. He could have talked about his case without ever posting her information, but he put it up there clearly for all his followers to see so that they could see in the slapping style sanctions video where he's putting up her work address. And then in the other video, the public, I forgot the name of it, but publicly available public information video. He put that one up and that displayed her email address. It displayed her phone number. And both of those then caused the communication with the other. He knew that this would happen because he was on notice. As you heard from the testimony yesterday, Mr. Myers has acknowledged that he knows his followers reach out to the victim. He knows that this happens. So he's on notice of that. He knew that the nature of the type of the contact they have, and so he's still doing it. So he's still eliciting them to then reach out to the victim. The definition of harassment means conduct directed at a specific person, which would cause a reasonable person to be seriously alarmed, annoyed, harassed, and the conduct, in fact, seriously alarms, annoys, and harasses the person. So we know it's directed at a specific person. This isn't just him talking about his case. He directed it specifically at Shannon Walker by putting up her information. So he's then calling on his followers to reach out to her, because this is something he's had the history of doing this, of repeatedly putting up these videos for Shannon Walker and putting up the contact information so then people would reach out to her. And in fact, that is what happened. You heard some of the voicemails, you heard 2 of the voicemails that were admitted into evidence, and then you admitted into evidence for some of the emails that she was getting that were in response that happened shortly after he posted these 2 different videos with her contact information. One of them specifically references, it was the gentleman who was coughing throughout, specifically references the content that was contained within that slapping style sanction video. And so it's clear that that communication was in direct response to that video. It references the University of Arizona, which is referencing the injunction that he put up. And while we only played a clip of that, the court does have the full video. And in the full video, he does go through and talks about that there was this thing in the police report that referenced the X, and that he talks in that video about that, and then that voicemail does reference that. So harassment, you have both the objective standard and the subjective standard. So you have the objective standard of what a reasonable person, would they be seriously alarmed, annoyed, and harassed by this conduct. And with the emails, the content of these emails is referencing, you know, her being raped, her being shot, things happening in front of her children, these voicemails of going to her home. This is all conduct that would cause a reasonable person to be seriously alarmed, annoyed, and harassed. And then you also heard Detective Brown reference that Shannon Walker is in fact seriously alarmed, annoyed, and harassed because she's afraid for her family, she's afraid for herself, so she has safety concerns. So we have both the objective and that subjective standard. And so these elements have been supported at this hearing under Article 2, Section 22. The standard is proof evident, presumption great. And we have the videos that were produced by Mr. Meyers. So we have the evidence showing that he was doing this, the testimony indicating that he knew this is what his followers would do, that this has been going on for a period of time. So this is repeat communications. And then we have the result of what happened when he then caused a communication with another by causing his followers then to reach out to Shannon Walker. So for those reasons, we would ask the court to find that we've met that standard and to hold him without bond.
Thank you, Ms. Stiles. Mr. Parvin.
Thank you, Your Honor. Your Honor, as there appears to be many people watching this proceeding on YouTube, I'm going to explain a little about what this proceeding is not. This hearing is not about whether Lane Meyers is guilty or innocent of any crime. This hearing is not about the 14 charges already filed with this courthouse. This court. The rules of evidence are more relaxed for this proceeding. This is not a trial on the evidence. This hearing is only about 2 alleged incidents involving YouTube. Both the United States and Arizona constitutions favor pretrial release. People are presumed innocent. People should not be in jail where it is incredibly hard to defend oneself. Arizona acknowledges this fact under the rules of criminal procedure and requires the least onerous conditions release necessary for the situation. Bail is a right in the state that should not be taken lightly. Before this court can deprive Mr. Meyers of his right to bail, his constitutional right to bail, it needs to find that there is proof evident, both that Mr. Meyers was in fact on pretrial release and that the alleged conduct was a felony. What is proof evident? Proof evident is more than probable cause. In fact, it is more than a preponderance of evidence. Although the courts have ruled the level of proof does not need to be beyond all reasonable doubt, unlike a jury trial, the courts have made it clear this is nonetheless a high standard of proof. It must be clear to this court that a felony was committed on pretrial release. Let's start on whether this even happened on pretrial release. The detective testified he thinks these videos were made after Mr. Meyers was on pretrial release. However, Detective admitted he had no way of knowing for sure when the videos were made. He didn't know the time. He appears to be going off what he thinks YouTube may have labeled it as, but he doesn't know for sure. The state didn't submit any evidence of timestamps proving when these videos are made. Furthermore, the minute entries were not entered until March 17th. There simply was not time to enter anything on March 14th. The hearing ran late. It was heated. Security was here. Mr. Meyers was escorted out to the situation because it was so heated and told to come back the following week to meet with pretrial services. Given this situation, how late it ran, as the court noted, we ran late yesterday too. It had to be continued. Same reasoning. I argue that the proceeding was not official until the 17th, when the minute entry was filed with the court and Mr. Meyers officially knew his release conditions based on that minute entry, given how heated it was and had to be escorted out. However, the biggest argument here is that the conduct stopped. I asked the detective if there were any further videos reported. He said no, or not that he was aware, but it was a no. This means that once Mr. Meyers was given his release conditions and on pretrial release, he was aware of them and stopped all conduct of these videos. Mr. Meyers was not arrested on these new charges until March 20th, in court, by the way. He's doing his duty to come to court. He's always coming to court, never fails to appear. There were no videos posted on March 18th. There was nothing posted on March 19th. The conduct stopped pursuant to the detective's own testimony. Mr. Meyers was summoned to go to court. He knew these charges were coming. He was understandably upset and exercised his First Amendment right to make some YouTube videos expressing his concerns. He was not on pretrial release when he received the summons. The fact that these videos stopped before he was arrested for these charges a few days later, that has to mean something to this court. This shows that the court's order of pretrial release was obeyed once it was official. This court should not deny Mr. Meyers' right, his constitutional right to bail, on a timing of incidents so close together when the testimony shows the videos stopped. I am not arguing the state can't charge Mr. Meyers for what they believe were contained in these new videos. I am arguing that there is no proof evident these incidents occurred on pretrial release. The conduct stopped. This court should not deprive Mr. Meyers from his right to bail when the evidence shows he complied and stopped making videos. Next, I want to discuss whether a felony even occurred. The state argues that two clips presented to this court rise to the level of aggravated harassment. However, if the court reviews the state's own exhibits that they submitted to you, the email started March 15th. If the detective believes, but again, he's not sure when exactly, but if he believes that the videos happened later, then why did the emails in response to these videos start on March 15th? Either the videos occurred earlier in time, which means Mr. Meyers was not yet on pretrial release, or Ms. Walker's email was already known to the public, in which case Mr. Meyers was not responsible for this, what happened after. Or maybe it's both. But no matter which route the court prefers, it's the same result. There simply is no proof evident here. The state cannot meet its burden to deprive Mr. Meyers of his highly important constitutional right to be released pending trial so he can defend himself outside of custody. Finally, there is the content of the alleged videos. In the first one, Lane Meyers is simply defending himself and explaining a court document. Is the state really arguing that the explanation and posting of a court document listing the University of Arizona Law School's address somehow caused people to mail? Nowhere in that video did Mr. Meyers tell anyone to contact Ms. Walker. He simply was explaining his legal proceeding and how he feels about it. That's not a crime. Certainly wasn't a felony. Maybe the court made a mistake in not listing the law school's address as confidential. Maybe it should have been. I don't know why the court, left that non-confidential on this injunction. However, if there was no mistake here, then certainly there's no crime in posting the address of a law school. The court should see this was a legal discussion in this video and had nothing to do with contacting Ms. Walker. In fact, the first thing the state mentioned was it requires intent. Clearly, there's no intent in that video to harass anyone. It's just explaining an injunction order and how he feels about it and how he's defending himself. The second video is admittedly slightly trickier. However, as the court saw, this video was silent. It was labeled public information. Ms. Walker's information was not the only one listed or displayed. The video went through several pages of the University of Arizona's website and showed numerous people and their credentials. If the court reveals the entire video, although we only saw a clip, even more names are listed. Public information. Now, it perhaps would have been more prudent not to post anything at all once the summons was received. With that being said, Mr. Meyers has a First Amendment right to talk about his case and explain how easy it is to see public information online. If the video were solely focused just on Ms. Walker's contact information with instructions to contact her, that would be one thing. But it was a constantly changing video, as the court saw, flashing various things real quick, showing many people. That's not a felony. Now, lots of people were upset when Mr. Meyers was charged. Lots of people watched the live streams as he was arraigned. As has already been established, lots of people must have already had her email. Or if they didn't, these videos were posted earlier and he wasn't on pretrial release. It's one of the two. Lots of people were upset. What we heard yesterday about what others, not Mr. Meyers, third parties, I don't know from where, what these third parties, these people are doing, watching these videos, he's commenting, what these emails, it's disgusting. It's despicable. I think it made us all cringe, myself included. That is just one of the most awful things I've heard said to someone. It's sad. No one should be doing this to people. However, it was very clearly established, including by the detective's testimony, that Mr. Meyers was not initiating these emails or phone calls. Mr. Meyers has never posted anything private about Ms. Walker. He would never initiate a contact like that. This isn't coming from him. These people have her email already. How they got it, I don't know. But it wasn't from these two videos. Now, I don't know if whatever Mr. Meyers did in those already 14 charged offenses caused these horrible things that's now happening to Ms. Walker. They might have. Sadly, yes. I don't know for sure. Mr. Meyers in the process of defending himself in all 14 charges. But whatever he did there, maybe that's what caused that. But that's in the past. That's not why we're here today. The only question today was, did these two new videos really rise to additional felonies? They really even committed while on pretrial release? They weren't, Your Honor. These two videos didn't add anything. At best, perhaps Mr. Meyers may have violated the injunction and might be guilty, based on that video, of a misdemeanor crime of interference with judicial proceedings. But that is not a felony. It does not deprive Mr. Meyers of his constitutional right to release, even if he is guilty, potentially, of the misdemeanor crime of violating that injunction order. With that being said, for all the reasons already mentioned, I ask that this court grant Mr. Meyers release conditions here, because the state simply cannot meet their burden here to deprive Mr. Meyers of such an important constitutional right to be outside of custody and defend himself. I'm not arguing the state can't pursue charges. They clearly have. They have some strong evidence for those 14 charges. They do. But Mr. Meyers also has the right to bail. The state simply cannot take that away based on this evidence today, simply for these 2 extra videos that did not rise to additional felonies. Mr. Meyers should be able to defend himself for those 14 charges, and if necessary, these last 2, which questionably may be additional charges, but not. I don't think there's enough proof for felonies here, Your Honor. And with that, I ask that you issue some perhaps quite stringent release conditions to ensure this, that everybody's protected here, the victim, but definitely issue release conditions. I think Mr. Meyers deserves that. He's entitled to it. The state has not met their burden, Your Honor.
Thank you, Mr. Parvin. Ms. Stiles, last word.
Your Honor, the only thing Ms. Walker did in this case is she happens to be married to a prosecutor. She had no connection, as you heard in the testimony, to Mr. Meyers, absent her relationship with her husband, that brought on that Mr. Meyers then started this retaliatory smear campaign against Shannon Walker. He turned these people onto her. And so you heard testimony about the backstory, that this had been going on, that he had started posting on her and then causing his followers to be reaching out to her. He then, even though there was an injunction put in place, and the injunction tells him, do not have contact, do not cause contact, do not post her work address, he was put on notice of all of this. He is put on notice that this was happening to her, and yet he continued doing it. He didn't stop, he just kept going. And so then you hear that he's put on release, like he's at the hearing. So this argument that maybe he didn't know because it was a heated hearing, he was at the hearing in person on March 14th. He was present. That's when the court ordered the release conditions. That's when he was notified he is on release. He had his arraignment. He was informed of these felony charges. So he knew he was facing all these aggravated harassment charges, misdemeanor charges, the felony charges of aggravated harassment, a stalking charge. So he was on notice of all of these things. And as defense counsel noted, there were a lot of people that were very heated and upset about this. But what did he do? He went online again on the 16th and 17th, and he posted her information again, even though he had been on notice that this was causing all this harm to her, that it was causing these people that were following him to do this. And so he went into it. We don't have to show that that was his intent. The other standard is that he knew that he was harassing another person by causing a communication with her. So he is providing the means for those people to contact her by giving the address and the phone number and the email. So maybe some of them had it, but he was definitely making sure more people had it, because there would be no reason for him to be posting that information to those people other than calling on them to then contact her and take that anger that they had and direct it again towards her. Again, because he's retaliating for the fact that he is now facing these charges. You heard the detective testify that he himself, when he went on YouTube to get these videos, that he himself was able to see when these videos were posted. And then the court got the voicemails that then came right after it, showing that this was in response to what he was posting. So he was calling upon these people to do that. And this isn't where we just have to say in this vacuum of just these 2 charges, the history matters into what showing that his intent or his knowledge of this. And so that's why you heard the detective testify about that history, that he knew what the response was going to be. He did it anyhow. And so it meets that standard of that he meets both the objective and the subjective standard of causing that harassment to Shannon Walker. He caused that communication, knowing he had an injunction, knowing she didn't want to have contact with him, and knowing what his followers were going to do. And he did it anyhow, even with all that knowledge. And sure enough, it did exactly what he was setting out to do. She got that contact. She got those harassing emails. She got the harassing voice messages that scared her for the safety of her and her family, all because she just happens to be married to a prosecutor and had no other connection to this man. And so for those reasons, we're asking that you find the standard that the elements of showing that he was on felony release have been met, and the fact that the elements for the aggravated harassment, which is a felony, we have 2 different dates. The court only needs to find one, but the aggravated harassment was met, and we're asking you to hold him without bond.
Thank you. All right, folks, I'm going to jump off the bench, take a few minutes so that I have an opportunity to review the documents that were provided. I do intend to rewatch the state's exhibits with respect to the 2 videos. So give me about 10 minutes. I just want to make sure I'm very clear on what we saw yesterday before I issue my ruling. So stay seated. No one needs to get up. I will be back. Give me, I would say, about 10 minutes, and I will rule from the bench. All right, and we are back on the record. I appreciate everyone's patience. I want to make sure that everyone knows what's been going on for the last, I think, closer to 40 minutes now. When the court got back in chambers, I wasn't able to view the actual CDs without a laptop, and one was not available for the court. So I did ask Ms. Stiles and Mr. Parvin to come back to chambers along with the iPad that the state used so that the court could view the redacted portions, or the portions that were played in court. Once back there, counsel did ask the court to review states 12 and 14, which the court did. So I had a chance to view most of all of those videos. I will say that for states 12, that was the one from March 16th of 2025, slapping Stiles sanctions. That one we did skip through. It was almost an hour long, and the portions that the court viewed with counsel in chambers were the portions that contained documents. There were several portions where Mr. Meyers actually was depicted, I think, wearing a t-shirt and a hat, but the court did not view any portions of the video that had just Mr. Meyers on it. So unless there was a document displayed on the screen, the parties did fast forward through that. So I want to make it very clear what this court has had the opportunity to review with respect to this case. So I did review states 12 in its entirety. And that one was about 16 minutes in length.
I think you said states 12. Is that? Okay.
It should be states 12. I had the full clips as states 12 and states 14.
I just want to be clear, it's the publicly available public information is the one that you viewed in its entirety.
Yes, sorry, and that is, you're right,
So that
Exhibit
was-
14.
Yes.
Yep, Exhibit 14 is the one from March 17th of 2025, publicly available public information. That is the one that was 16 minutes. That's the one that the court viewed in its entirety. There were no conversations between the counsel and court that had anything to do with this case other than literally looking at the videos and reviewing the information and the content that the court wanted to view before making its ruling on this case. Ms. Stiles, anything you want to add to the record that the court made?
No, Your Honor.
Mr. Parvin?
No, Your Honor.
All right. So the purpose of this hearing, and I think Mr. Parvin said it, this is not about whether or not Mr. Meyers is guilty or not guilty of the charges that the state may be going forward with respect to this case. What the court is being asked to decide is whether or not Mr. Meyers should be held without bond at this time. Arizona Criminal Rule 7.2 is very clear that defendants charged with an offense not eligible for bail under 7.2 V1, someone is not eligible for bail based on a commission of a specified felony or any felony while on pretrial release. A defendant must not be released if the court finds that proof evident, presumption great that the defendant committed under B, any felony offense while the defendant was on pretrial release for a separate felony charge. That's what the court is having to decide today. In reviewing the evidence presented in this case, the evidence presented in Exhibits 6 through 10 do establish that Mr. Meyers was on release on another felony matter when the offenses in this case were committed. What that leaves is whether or not there is proof evident, presumption great that the charges the state is going forward with today have been established. In reviewing the two videos, the first one, Exhibit 12, that's the one that occurred on March 16th of 2025, entitled Slapping Style Sanctions. The court will note that in reviewing that information, there was a portion of that video where Mr. Meyers specifically talks about his X or an X and emphasizing the fact that there was an X. And as the state's evidence established during Detective Brown's testimony, there is a police report also shown in this particular video that makes reference to Mr. Meyers as being an X. I don't think that that's actually the case. That was the evidence, but that was the information that was displayed during this video on March 16th of 2025. That information is important to the court because not only does a caller later in that video actually call in and mention the fact that this appears to be retaliation for an X or an X retaliating for information, I think that specifically ties back to the fact that the viewers are responding to the information that was posted on March 16th of 2025 in the subsequent emails and phone calls that are made to Ms. Walker in this case. So I do think that the context of the information that is being displayed certainly ties back to the information that was presented with respect to this video. In that video, I will say there was a brief section that I did not review at all, from I think 117 in the video to 137 was something we skipped through in its entirety. So I don't know even the content that was on that particular portion of the video. So I want to make sure that I have that in there as well so it's clear what the court reviewed. In reviewing the information for the March 17th, 2025 publicly available public information that was 16 minutes, I will note that while there were a number of people that were displayed during that particular video, the initial portion of the video did display Ms. Walker's phone and email, as well as a photograph of her on the University of Arizona website. As the scrolling goes down through many of the pictures of other people at the U of A Law School, there is a significant pause when Ms. Walker's photograph and information comes up before he continues to scroll down through other people that were employed by the law school. There are many times during the 16 minutes where he stops and focuses specifically on Samantha Walker, her achievements,
Your
the
Honor,
fact
Shannon Walker.
Shannon Walker, I'm sorry, the fact that she was a key contact at the law school. I will note that there was a portion where there was a focus on, very briefly, Samantha Walker, which is a different person that was also stopped on again very briefly, but it was very clear during this 16 minutes that he continued to focus on Shannon Walker. There was, in fact, a portion as he was scrolling through where there was a photo of Miss Walker with her husband and her children, where she is shown as a member of the board of directors, and again, very much focused on her throughout that 16 minutes from the March 17th, 2025 video. Mr. Meyers has the YouTube channel where a number of people follow. Based on the entire context of the communication in this case and the information provided to the court, I do find proof evident and presumption great that Mr. Meyers did commit these offenses. That's only for the purposes of, obviously, this hearing as it pertains to the aggravated harassment involving Ms. Walker on these two videos, so those two counts. And again, looking at ARS 13-2921, harassment, as the state pointed out, a person commits harassment if the person knowingly commits any one of the following acts in a manner that harasses, Under A1, contacts or, this is the part, causes a communication with another person by verbal, electronic, and other means. It is the electronic means in this particular situation. And under E, it defines what harass means: conduct that is directed at a specific person that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed, and the conduct, in fact, seriously alarms, annoys, humiliates, or mentally distresses the person. There is no doubt, and I think even defense conceded, that the contacts with Ms. Walker in this case are truly offensive and would certainly cause a reasonable person to be annoyed, alarmed, and distressed, mentally distressed. The aggravated harassment statute under 1329-2101 requires that a person commits aggravated harassment as provided in the underlying statute that I just related, and at the time of the offense, any of the following applies. Under A1B, an injunction against harassment pursuant to 12-1809 was issued in this case and was enforceable. For those reasons, the court does find that Mr. Meyers is going to be held without bond today. Anything else that we need to do on this matter from the state's perspective?
No, Your Honor.
Mr. Parvin?
I was just saying, if the court's finding proof evident, can we go straight to arraignment so we can start the 150-day timing? I'm wondering if instead of waiting 10 more days, I understand there's an indictment coming already. I'm saying if the court's found proof evident, that's more than probable cause they're getting. If he just wants to have a speedy trial rights and start the 150 as soon as possible.
Ms. Stiles?
Your Honor, the charges are still set to go to the grand jury, so that process hasn't happened yet, so we don't have the charges to be able to do an arraignment today. If they're wanting to waive a probable cause determination, there are forms that we can prepare to do that. So that's up to, but I'm going to say there's going to be additional counts that go through as well, but I can present those to the defense. If he wants to waive the probable cause determination, we can do so. If not, it will be proceeding to the grand jury.
I think I think it's 10 days. I know we're at March 31st, still some time there for that to be done. But Mr. Meyers does want to invoke his speedy trial rights and wants the 150 to start as soon as possible.
Understood. And I think for purposes, again, of this hearing, the court only has to consider one charge. I think the state does have the ability to go forward on other charges. And it does sound like these may not be the only two charges that the state does intend to proceed on. So I'm sure Mr. Meyers and Mr. Parvin, you obviously will continue to assert his rights going forward. Anything else that we need to do today?
No,
All right.
No, Your Honor.
Thank you all.
I think this case is really going to be one that is going to set a precedent going forward for this kind of thing on the internet. There are so many people that will do and say whatever they want and then just claim First Amendment protection. But the thing is harassment is never going to be protected speech. And that's what these people are doing to this woman. It's truly, truly revolting. And I don't think he's going to get out of this. Thank you so much for watching, guys. Please like, comment, subscribe. Let me know what you would like to see, and I will catch you on the next one.